Alex here with a legal nuts and bolts video on the duty to mitigate damages. I talked about this in my last video. I did promise to do it next, so I'm going to go ahead and do it now. I'm going to go ahead and use the example from my last video since I think that helps people understand it the most. The example in that video was that, let's say there's a landlord-tenant relationship and they were in a one-year lease and the tenant decided to move out, like, we'll say 5 months in. So that's 7 months early. And that's obviously a breach of contract because the tenant agreed to stay there for a year. So the amount of, in this context, because I also talked about other ways that landlords can try to attack. Sometimes they'll attack with like a lease break fee or something like, or maybe making you like waive your security deposit, but I don't want to talk about those in this video. I wanted to talk about just the duty to mitigate damages. And in that context, it was the whole argument that the landlord is entitled to all those other months of rent that they would have gotten from you had you satisfied the lease. So in this case, that would be 7 months worth of rent, which is a lot of money. They can claim that, but the problem is the thing that gets in their way is the duty to mitigate damages. At least from what I've seen working in collections, 2 years when I was in college in Reno, the judges take that, it's an affirmative defense, by the way. I'm not sure that I mentioned that yet. The judges take that affirmative defense pretty seriously. If a landlord is going to try and collect for, and of course this can apply to any other area where you can bring up this principle of duty to mitigate damages, but this particular one with tenants who moved out early, it came up a lot. The landlord is expected to try and get somebody else in that unit as quickly as possible. They're not supposed to just not care, leave it vacant, and then bill you for the next 7 months. They're not supposed to do that. They're supposed to try, and that's what where the duty to mitigate comes in. It's a duty, it's an obligation. Whether they like it or not, it's imposed on them. The second that the contract is breached, they have an obligation to try to make sure that the damage they suffer is lessened or minimized or mitigated. That's the word. That's the one of the words in the phrase, duty to mitigate. But anyway, if the landlord does successfully mitigate by getting somebody in the unit, then they can collect damages only for the amount of time that they actually suffered. So let's say they get somebody in there 2 months later, they should be able to collect 2 months worth of damages from you if they take it to a lawsuit. They shouldn't be able to collect a full 7 because they got somebody in there 2 months after you left early. If the landlord doesn't get anyone in there, then they better prove to the court that they tried as hard as they could to mitigate. Because if they don't, the court's going to sort of impose, I guess you could say the court's going to sort of, I don't want to use the word guess. The court's going to do the best that it can to come up with a date that they reasonably think the landlord could have gotten somebody into that unit. And they're going to only award up to that amount in damages. So the landlord's just going to eat a massive loss. We'll say the judge, we'll say the landlord just didn't even bother getting anyone in there and they sued for 7 months worth of rent. We'll say the judge just found that their efforts failed to satisfy the duty to mitigate, that they did not try hard enough, that they could have got someone in there and they didn't. And we'll say the judge says that maybe after 3 months they would have probably gotten somebody into that unit. And of course you can try and prove this, you can assert this. I'm going to go into that a little bit later. Then that even though they suffered 7 months of losses, actual losses, because they didn't have somebody in there for 7 months, the court will only give them those 3 months that they that the court came up with as to the timeline that they should have, had somebody else in there. So they'll be, the landlord in that case would eat 4 months of losses because they would not get that money in damages. The last thing I was going to mention is you kind of, in small claims court, a judge might help you a little bit, but in a formal lawsuit, it should be raised in the answer. You should specifically raise that or assert that affirmative defense, the duty to mitigate. And then, of course, as a defendant, you can push that in court. You can argue that you did breach, but the landlord should have gotten somebody else in there, and you can sort of demand documentation or question the landlord, or you could approach that just like any other legal issue and try to sort of prove that the landlord could have gotten somebody in there, and that if they did, they wouldn't have suffered as much in damages as they actually did by not trying hard enough. So I hope that this video makes sense to people, because it's not really meant to be a landlord-tenant video, but I feel like this example is one of the most common that we encounter, because a lot of us, we rent, apartments or homes, And this ends up being one of the places that the duty to mitigate actually gets used a lot. And when I was working in collections in Reno, the judges took it very seriously. They typically would only award a couple months, 2 or 3 months. If a tenant moved out a year early, they didn't care. The judges in Reno, they wanted those landlords to be put on notice that, if somebody moved out early, too bad, so sad, get somebody in there. And I'm not saying too bad, so sad, you're not going to get any money for it, as much as I'm saying, don't expect to get a massive windfall as a landlord. You got to try hard. You got to get somebody back in there if somebody moves out early. Um, and if somebody moves out a little bit early, like maybe 2, 3 weeks, maybe a month, month and a half, they'll probably get all that money. As a landlord, they'll probably get the full amount. But if somebody moves out like 7 or 8 months early, if they think they're going to go into Reno Justice Court and get 7 or 8 months worth of damages, they're dreaming. Unless the tenant doesn't even show up and they get a default judgment, then that'll probably actually happen. That's one of the lessons that people should take from this, is try and fight these things, even if you're in the wrong, because you may lose, but you can at least control the damage amount. You can at least control how much you lose by. Don't just quit and not go because you're afraid of being yelled at or made fun of. The judges don't really do that. They don't make fun of you or yell at you unless you're trying to do something ridiculous in the courtroom. They're just really trying to resolve the legal dispute. And so if you're in the wrong, you move out like 9 months early and you're in the wrong, don't just skip court. File your answer, go to court and talk to the court and explain your situation. You're going to end up losing, you're going to end up paying, but you can at least reduce that amount significantly, because the judge, at least in Reno Justice Court, from my experience, will actually impose the duty to mitigate on the landlord. They will do that. And anyway, it kind of went off on a little bit of a tangent, but um, as I was mentioning, this really isn't just a landlord-tenant issue. Anywhere that breach of contract comes up, the plaintiff, if they sue for breach, does have the duty to mitigate that damage. And so in any other kind of context that you can think of where this comes up, you should be able to raise it, and if you can prove it, you should be able to reduce the amount of damages that you end up having to pay for. So I guess at this point, I'm going to go ahead and end this video, and I will see you guys next time.